The St. Kitts and Nevis Independence 41 Committee presents Conversations, Reflections and the Way Forward. This interactive discussion series provides an in-depth view of the trials and achievements of the past, as well as the accomplishments, threats, and tremendous opportunities of today and in coming years that will transform the Twin Island Federation into a model sustainable island state, serving as a beacon for all. On this edition, CCJ versus Privy Council, the battle for justice.
Would you stand up and see your country dying?
The St. Kitts and Nevis Independence 41 Committee presents Conversations, Reflections and the Way Forward. This interactive discussion series provides an in-depth view of the trials and achievements of the past, as well as the accomplishments, threats, and tremendous opportunities of today and in coming years that will transform the Twin Island Federation into a model sustainable island state, serving as a beacon for all. On this edition, CCJ versus Privy Council, the battle for justice.
Would you stand up and see your country dying?
Good afternoon, and welcome to this special edition of In Focus as we bring you conversations, reflections, and the way forward. I'm Leah Crag-Chaderton, and I'm your host for today. We have an interesting topic that lies squarely in the depths of our legal system, where the topic is CCJ versus Privy Council. We've had this debate about whether the Caribbean nation should fully transition to the CCJ versus the Privy Council as its final appellate court since the inception of the CCJ, which is the Caribbean Court of Justice. This was established in 2005, and it was to promote regional sovereignty in our judicial systems here in the Caribbean. Today, we'll explore the balances between our historical ties with the Privy Council and whether we should move to our own court where we serve our own justice. With me in studio, we have a host of exceptionally talented guests to dissect our topic today. Immediately on my right, we have Ms. Nisharma Rattan Mack. Next to her, we have Mr. Crios R. Freeman. And last, but by no means least, we have Talibah Byron. I'll hand over to them to introduce themselves, but stay tuned for an informative and engaging discussion. Nisharma, tell us a little bit about yourself and why you're here today.
All right. Hi, I'm Nisharma Rattan Mack. I'm an attorney at law. I have been practicing law for the last 11 and a half years or so, even though I look so young. Currently, I am the acting registrar of the High Court. That is my job by day, but I'm also a passionate enthusiast about anything law or anything educational about educating our population on law and sort of breaking down the barriers and kind of removing the veil of persons thinking that the law is so this thing that they can't attain. Just having those conversations. So I'm happy to be here and happy to share my knowledge with everyone.
Thank you so much, Nisharma. Crios, a little bit about you. Tell the people why we're listening to you today.
I have no idea why I've been invited, but I'm happy to be here. The thorn amongst the roses.
Got that right.
I'm probably older than anyone here, but the most junior lawyer. I have been practicing going on 6 years, qualified going on 7 years. I spent a little bit of time after law school at legal aid, and then about 2 years now I've been practicing on my own Freeman's Legal Services. I think that it is a conversation that needs to be had. I think that there is much that has been missing on this issue. I've been hearing about this since my days as a youth parliamentarian, and there has not been much movement. So I'm happy to be here to take part in the conversation and follow the lead of my more senior colleagues.
Fantastic. Thanks for that, Crios. We'll send you the bill for that advertisement you dropped earlier Talibah, tell us a bit about yourself.
Okay, thank you, Leah. And let me say thank you to the organizers as well for having me on the panel today. Apparently, I've had a bit to say in the past about this issue, and so my good friend thought that it would be fitting for me to join the panel today, and I hope I have something valuable to share on the topic. I've been in private practice since 2011, so 13 years now. During that time, I've been involved in a few matters before the Privy Council myself, and I've also undertaken an internship at the Caribbean Court of Justice. So I think I have a kind of unique perspective on the issue. Looking forward to the discussion today.
All right, let's jump right in. I'll start off with an easy question. So we have our viewing audience today, and they're probably wondering, what is the CCJ, what is the Privy Council, and most importantly, what's the difference between them? So how about we start with that? Nisharma, I'll start with you just because you're right next to me. Okay. So can you tell us a bit about the difference between these two courts and why it's so important?
Okay, I will start the best, and of course Talibah can jump in to assist with her experience that she's had. But I'll start with the Caribbean Court of Justice first. We have, since 2001, signed on for where this court has been created. It actually became operational in 2005, where you have the initiation of the Caribbean Court of Justice. It stems from our revised Treaty of Chaguaramas, which is signed on by our CARICOM member states, to foster that unity, develop those deepened ties within the Caribbean, looking at our single market and economy, looking at the Caribbean islands coming together as one block, whether economically, developing nations, what societal needs we'll be pushing as one Caribbean region. And the court is no different, having one court for the Caribbean, creating an indigenous jurisprudence that belongs to us. And that is actually pretty unique for the Caribbean, where we've had many, many famous legal jurists. And so this is the court of creating our own as our final appellate court and ending ties with the Privy Council, which is from our colonial past, which is the Privy Council. The court is unique in that it has it's divided into two sections. So you have the court sitting as an appellate jurisdiction, where when you appeal cases, whether from High Court up to the Appeals Court, then to the Caribbean Court of Justice, but it also has a unique function in that it operates as in an original jurisdiction, also looking at the countries and ensuring that we are complying with the revised Treaty of Chaguaramas. And we've had many cases in the region looking at that original jurisdiction, which makes the court quite unique in that regard. And so I would like to say that is the difference, really, with the Privy Council and the CCJ, because in it has its inherent original jurisdiction, where you don't have to actually go to the function of the appellate jurisdiction, but the original, just by virtue of being a CARICOM member state.
So the first point of contact for this case, so, typically a case either starts at magistrate court or starts at high court, but you don't have to go through all the steps. You can just go to the CCJ for these particular matters.
For these particular type of matters.
So I'll hand over to Talibah to tell us a bit more about those types of matters, those that you can take directly to the CCJ. You don't have to go through the court system.
Absolutely. So as Nisharma said, the revised Treaty of Chaguaramas sets up the original jurisdiction of the Caribbean Court of Justice. So disputes which happen under the revised Treaty of Chaguaramas, disputes which have to do with any rights which are set out in the revised treaty, those can only be adjudicated at the CCJ. The CCJ has...
Not to cut you, but the revised Treaty of Chaguaramas, just tell us what that is responsible for, what that covers.
Okay, all right. So it deals with the single market and economy. There are rights for freedom of movement. One of the major cases which most people might know about is the Shanique Myrie case against Barbados, That was a case in which a citizen of Jamaica, Miss Shanique Mary, she traveled to Barbados by plane, and as a visitor, she was not allowed entry. She was actually subjected to quite a humiliating experience and cavity searches and the like, and she was not admitted entry. Now, under that case, the CCJ, that's one of the most famous cases, I would say, the CCJ in its original jurisdiction heard Miss Mary's case against the state of Barbados and found that the state of Barbados had breached her rights to freedom of movement into the state of Barbados. So those
as a CARICOM national.
As a CARICOM national. And so those are some of the issues that the CCJ in its original jurisdiction deals with.
Okay, great. Crios, I see you and you look a bit left out, so come out and play with us. Can you tell us a bit about the historical impact, or how has the Privy Council impacted our justice system in St. Kitts and Nevis historically?
Well, one must understand the historical development of St. Kitts and Nevis. We were once a colony of the United Kingdom of England. And so moving out of that and into independence, we kept that court as our final appellate court. And that's where most Commonwealth countries came from. That is the court that, and people have to understand, yes, the magistrate court here, the High Court, the Court of Appeal. This is where the buck stops. It doesn't go any further than the Privy Council for most matters. Of course, there are some matters, election matters and so on, that end, some election matters that end at the High Court. The Court of Appeal. You don't go to the Privy Council on some of those matters. And so that is the history of the Privy Council. Because we were colonies, coming out of that, we felt that, yes, we can take on certain things on our own, but this is where the buck stops when it comes to appeal matters. And so that is where we have been since 1983, when we became independent. We have not gone any further than that. The impact, I think it has served us well. Of course, when we get into conversations about what we see in other countries, the United States, the United Kingdom, sometimes we forget that these countries are 200 years old. They have been established long time. But I think that we have been given the opportunity to develop. And so our trust and faith was placed in this court. And so I think that for the most part, there hasn't been a problem with the cases that are decided at the Privy Council. And we know that it's not that we see hundreds of cases going to the Privy Council. There has to be some extraordinary legal issue for a matter to go to the Privy Council. But of course, this is a substantive issue for civil matters, criminal matters, human rights matters, big money matters, for party against party cases. And so it's critical. And I don't think there is an argument anywhere that somehow over the years that we have gone to the Privy Council, the Privy Council has been our final court of appeal, that we get judgments that are not sound, riddled with error or anything like that.
What about the, I wouldn't call it a general consensus, but the small voice in the back of the room that says the Privy Council is akin to allowing a group of, should I say it on air? But you get where I'm going. A group of older men, significantly, of a different ethnicity, determining issues that affect our people. And what would you say to persons who say that those men typically are not in a position to understand how their legal decision would implicate us here in our society?
Of course, there are arguments on both sides, because in law, what you want is, independence, is transparency, and so on. And so there is an argument by some that this is as independent as you can get, that these people are far removed from the circumstances on the ground, and so they don't see bias, they don't. But of course, that is only an argument. There is a counter argument that people who are making decisions about these substantial legal issues should know the impact that these issues are having on the country and the people that these decisions are being made for. And if you are so far removed, then you cannot fully appreciate what is impacting your decision and how your decision will impact this. But I think the most glaring example is when we were tuned into the boundaries matter at the Privy Council, that the court could not appreciate how the law could have been passed, and then 5 minutes later, the Governor General could have done what he had to do. In a St. Kitts context,
right.
The Governor General is 5 minutes away.
Correct.
Or he could have been in government headquarters on business and waiting. Of course, if you're in a London society, it's hard to see that happening.
Lower.
Right?
If I can add to what Crios said, one of the things I want to add, and this is why I said this is my passion part coming through now, is I think persons think that judges, all judges, we're humans. And you have to understand judges are human beings just like us, just like lawyers are. And biases exist in each and every one of us. And that hasn't been an argument long prolonged, I think, by our society, Caribbean society on a whole, and even here in St. Kitts, where you have to understand they're human beings and everyone has a bias. But when you're in the judicial system, you have to sort of face your biases frontally, look at it, acknowledge it, and realize when you're making decisions, you have to face that and come around it. So biases will always exist. And I'm certain the very judges in the Privy Council have their own biases. Exactly. And so we have to come to that realization that it will exist, whether it's in the UK, whether it's in the Caribbean region, whether it's anywhere about. But you have to just face those things frontally, and the judges, they know how to deal and manage those things. And I think we just have to accept that it is something you have to deal with. It's on the table, and we have to deal with it. So I don't think whether the UK, it's going to be all over. That bias will be there, and it will come through. But it's our jobs within the profession, like Crios said, to do things with integrity, with transparency, with looking at both sides of the argument, whether they're judges who make decisions that they absolutely don't agree with. And this is something that we have to discuss and be open about in discussing in the region. I think we have a lot of issues with trust and confidence, particularly with our political climates and how we engage politics in the region. But it has to do with a lot of trust and confidence. And I think once we start to tackle those things and kind of delve deeper into it, we can have those discussions or those deeper discussions about it. Because I personally think us going and transitioning is the last process in our completing our independence, our true independence.
You're jumping the gun. We'll wait. But before I get to Leah, Talibah wanted to weigh in. And while you're weighing in, Talibah, if you could just touch on the legal implications of us still having the Privy Council as our final court of appeal.
Yeah, well, what I wanted to weigh in on, as you mentioned, the distance issue between the Privy Council and our countries here, in particular St. Kitts and Nevis, it occurred to me to mention that even the Privy Council judges themselves, stemming back hundreds of years actually, have observed themselves that it is a weakness of their court that they have no understanding and appreciation and in-depth knowledge of life here in the Caribbean. They do not live here, they do not work here. Many of them will have their whole careers and never visit once. And so they've accepted that. I found a quotation from 1820, I'm going to get to that. From 1828, the Lord Chancellor of England at that time actually advocated, his name was Lord Rattan. And actually he was pretty progressive for his time. He was instrumental in the passage of the Slavery Abolition Act in 1833. So this was 5 years prior when all of this discussion was happening. And in 1828, he made the case actually that the Privy Council can't be of much use to us here in this region. Because of the distance, because of the foreign culture and all of that. You come closer up to our days, Lord Phillips in 2009 made the point as well, not only of the distance, but also of the strain that our cases put on the judges in England who have their own cases to deal with, and ours are, they have to just do this as a kind of favor to us. Favor? Because we're still joined.
I'm happy you're going back into the economic implications, because then we really decide whether or not it's a favor.
Yeah. So I think now Lord Reid, who is the president of the Privy Council, now softened his tone a little bit in terms of coming out and acknowledging that, Privy Council, he's in favor of retaining it for our countries. And recently what has happened is, because the Privy Council recognizes that they have the weakness, which is that they can't relate to us, they've made the announcement earlier this year that they would begin to have overseas judges sit for a time on the Privy Council and hear some cases. This is not something new. It has happened before. Sir Vincent Floursac, who was a former Chief Justice of the Eastern Caribbean Court, he has sat on the Privy Council in the 1990s. The Right Honorable Telford Georges sat on the Privy Council. Sir Edward Zack of Jamaica sat on the Privy Council, and so on. But that happened before, and it sort of stopped, because of what was happening at the time, but it is starting back again. But it's just interesting that it is starting back because the Privy Council acknowledges that it is a weakness. It is a weakness that there's so far. It's not a strength. Mm-hmm. They recognize it as a weakness.
Okay, and we take that point, but back to the favor. Explain to us then a bit about the cost associated with moving a case. Let's say we're at the Court of Appeal, we are unhappy with the judgment there, and we decide to avail ourselves of the Privy Council. Mm-hmm. Let's discuss a bit about the cost to the client.
Good. So the first thing you have to do when you want to get a case to the Privy Council, assuming you get permission, you need leave to appeal to the Privy Council. So let's assume you've gotten that leave or permission, which is a process in itself, but let's assume you've got, in terms of cost, in terms of time.
So we try to...
Okay, so once you've gotten that, you need to retain a solicitor in England. You're lucky to find one for less than £20,000. You have to pay that person. You can't have a Caribbean solicitor. You need a UK solicitor based in London. You pay that person to file your papers, to make sure things are in order. More than likely, you have a local lawyer in St. Kitts and Nevis working with that person who you're paying as well to finalize those papers.
So we're paying 2 lawyers?
Yeah. You're paying at least 2 legal. You're paying at least.
Right, 2 sets of fees.
At least
to start. Mm-hmm.
And then...
I just wanted to clarify that.
Of course. So you can, as a local lawyer, we have a right of audience before the Privy Council. And so Crios, any one of us, can get up tomorrow and argue a case before the Privy Council. Most people prefer to retain a British lawyer to do that arguing for them. You mentioned the Boundaries case and so on. And that's because those lawyers, they have more experience with those judges, their accents sound better.
So apart from the solicitor, who, because
Does the paperwork. The solicitor does
You have
not
to
do
get
the
a barrister.
arguing.
You have to get a barrister.
Get
So
a barrister.
this is a third lawyer now.
yeah.
So
Yeah.
3 sets of money paying, as people would say. Okay,
And so
And
you're
that cost-
talking like, I mean, and if you want a QC, or no, they call it KCs.
KC, King's Counsel. yes.
£75,000, things. It depends sometimes on the nature of the case and the amount of money involved. If you want to get a lawyer, maybe you can't get the QC. You want to get somebody who doesn't have that, but still has experience. You're probably talking like 35, 40,000 pounds.
Pounds.
Pound sterling.
Yes. No, I just wanted to get that out there as well, lest the people think
You
we're speaking
also
Eastern
have the
Caribbean.
filing fees for cases, and I would average that about £5,000. That's for the court. That's not lawyer
Wow.
fees.
Try to do some math. Anyone
right,
here strong
so-
with math?
And again, math is not my
Neither. I don't
biggest
think
strong
it's any
point.
of our strong points.
20, 40,
It's not a lot of money.
we're in the 70,000
Yeah.
pounds region.
If we don't get the
If you don't get the
KC,
case.
If you
Assume
don't-
you
Okay.
don't get that.
Yeah.
that's just pounds, and we still have to pay our counsel
And then,
here.
yeah, you still have to pay a counsel here. And, you know, sometimes you have these cases going through for years locally in the
That
High
was going
Court
to be my
and Court
next
of
question.
Appeal.
How many in-person visits are required by whether it's the
In-person
attorney, the local attorney, or even the local client? Is that required, or once you've retained the UK barrister, if you do, then the local attorney presence isn't required at all?
You just need somebody to argue. So if you've retained somebody in England to argue, then you have somebody there
So
to argue.
so you don't have to go there.
Your client may benefit greatly from having the person who did the High Court and Court of Appeal that probably took years to do. They have the continuity
Yeah,
and the
the
knowledge.
knowledge.
You may benefit from having that
Having them
person there
there.
at least to guide this
Well, it's
one
instructing.
who's just been
Right.
retained now, maybe a month or two before. You know, so you may want that.
So that's
as
additional
well.
cost
Yes.
for that travel. Okay. Just doing some
And
light math in my
these
head.
matters are usually sitting in a day, a week.
Yeah.
And half day a day.
Yeah.
Half
Okay.
day a day.
And how long does it take before your matter gets called up? I know
Oh,
typically
it
here we have
depends.
some challenges sometimes, in some instances, about the swiftness or lack thereof with which the wheels of justice turn.
Well, I don't know if it's fair to compare a high court or a court of appeals docket to a highest level of appeals
Because
docket.
the volume is
The
significantly
volume is
smaller.
significantly smaller. It's always going to be. And so if we have some scheduling issues with our magistrates court, which hears hundreds of cases a year, and a Privy Council, I went on the website and they've done, I think it's like 70. Sorry, they've done, I think it's 50 judgments on their website for the year.
For the year.
They have some more to go, I understand. They have some more cases to hear.
Okay.
But that's about what.
Yeah, that's ample.
But on
you
average,
have
it
it-
takes what, about 90 days before you get a date?
I'm told like a year and a half.
Okay.
I
Interesting.
think
From the time you file.
From the time you file, yeah, that's what I
I
mean.
think though, Leah, you know, as we're on the economic argument, I think, you know, a lot of the arguments can be about pure emotion, about where you see the
Yeah.
colonial conversation, the true independence conversation. But I think this one is the real
But that's why I wanted to get to
argument
it. My next
that-
question.
that
is-
it's because remember too, you have criminal trials, criminal matters that can end up before the Privy Council, especially when there is some human rights issue. You have civil matters, of course. I would imagine that for a civil matter, for a party to decide on whether they're going to the Privy Council or not, millions of dollars would have to be involved.
Pounds sterling?
But
or-
I think this is really the argument to be made about transitioning
Right.
and how cost effective.
And this brings me to my next
It can be.
question now, Crios. And since you're here, if you can answer it, I'll be grateful. If not, Talibah or Nisharma, feel free to jump in. Let's talk about the process now for the CCJ, whether in its original jurisdiction or as an appellate court, in terms of costing, retaining in local counsel, outside counsel, all of that. Is it a similar process, and what are the costs associated with that?
Well, I don't have the experience, but just deciphering what Talibah has explained, I think some of those costs are automatically dropped because my understanding, it's not dissimilar from the Court of Appeal. You're just stepping up to the final. And so we have counsels who argue before the Court of Appeal. As a matter of fact, throughout the OECS, the Court of Appeal comes to us, right? And I know that the CCJ is headquartered outside of St. Kitts and Nevis, but I'm sure that because it is our own thing, that there is some flexibility in whether we will always have to go to its headquarters or it can travel at any point in time. But the cost would be
significant.
And you're not required to retain a Trinidadian counsel.
No, you're
Exactly.
not. And I will chime in here because I did a bit of research on this one. And right now, with the move that the courts have been making, is especially through COVID, and sometimes we have to look at how we looked at our efficiency through COVID. And the courts now, whether it's the Eastern Caribbean Supreme Court or the CCJ, are now doing e-filings. We're going online. Everything now has been transitioning. The court is now doing Zoom trials. You can look at judgments being delivered on YouTube. That is the way, the technological advancement in the justice system has been top notch. And I can tell you, based on an experience I had with one attorney, he actually told me that during COVID, he was so pleased with the court, the Eastern Caribbean Supreme Court in particular, in transitioning to Zoom trials and Zoom hearings because it made the process so seamless. He said up to now he was in Hong Kong doing a matter and he's still waiting on that judgment. Whereas I think in the Caribbean we were able to make that pivot rather quickly, and the CCJ is no different, and they've moved to that as well. So you don't even have to travel to Trinidad and Tobago, where the headquarters are. You can actually do it in your office in St. Kitts, in your office in Barbados, in your office in Guyana. So they're looking at different ways as to how persons can, make the courts more accessible for our people.
Yeah. So and the CCJ is an itinerant court. That means it moves just like our Eastern Caribbean Supreme Court moved. Right. In the Shanique Mary case, it went to Jamaica and it also went to Barbados as well and sat there. And they've been doing Zoom long before Zoom was a thing. Yeah. Long before COVID.
Yeah.
And so that flexibility is a major advantage. Before we leave this part of the conversation, and it's not just the economic part, but I think it's a strong word, but it's a serious affront to us that so many years after our independence, we're taking a legal matter to our final appellate court, and we can't file papers for ourselves. That it's mandatory that we get a solicitor from the UK who has to file our paper. We can file our own papers up to the Court of Appeal.
I mean, I definitely take the point. We
are both,
and I agree.
Because this is connected to the whole idea of being truly independent.
Yes.
So it's an attack certainly on your pocket, and it's an affront to the extent that our local lawyers are dealing with these matters. We are called to the bar in our jurisdictions. The laws require us to go to this court as the final court of appeal, but somehow we can't do the work all the way.
For me, I think the affront tapered a bit once we started our legal training within the Caribbean. For my part, I could understand the argument that, well, they're unfamiliar with our system, they're unfamiliar with our processes, so for familiarity and to help with efficiency, utilize someone from our system. I could understand that. Then, no. But before, when our attorneys were trained in their system,
exactly.
Why wasn't that the case then? For me, that's where the affront lay, because it was like, we come here, you told us we have to come here if we want to do this. You teach us and then somehow we're still not good enough. This is my challenge with it. But so we're hearing economically, we're in favor of transition.
Yes.
We're hearing accessibility-wise, we're also in favor of transition because of the ease of accessing the court, especially in 2024 when more places are moving into the 21st century and accessing technology. What about political will? If you know what, no, let's table that. Let's get back to that. Before we get to the political will, it's just building up, building up. We're taking the people on a journey with us here. So we have these pros that we've established right here in the last half an hour. Are there any cons? One, are there any blocks to this transition? Because we just identified two major pushes towards it.
Yes.
What's keeping us back? Nisharma, can you shed any light on that?
I think I can. I think I've analyzed this enough. And just before I jump into the cons, I want to tell the listening public this. As a CARICOM member state, we already pay into the court.
Thank you.
We already contribute fees for the court to function, to operate. We are already taking our taxpayers' money and paying this court that we're actually not accessing, right? And as a people, we have to think about that. So I just want to end with that point. But to go into the cons as to why I think, persons would have, sort of a hesitation to join the court, I think it has to be, honestly, it's our historical past. It's our, how we were colonized, how some persons were made to think. I also think it's a lack of awareness. And that is what, it's a lack of awareness in that persons sort of associate the justice system sometimes with distrust. They associate it with, sometimes they come and they say, well, they didn't get their way, so it's not fair, it's not this, and the politics of how we've engaged politics in the Caribbean, in St. Kitts in particular, I have to say, we're very combative, draw lines, there's no coming together, and that creates a stumbling block. Because you have to look at this as a whole. You have to look at it. They look at it as, the judge can be bribed by this person, and that sort of narrative is propelled, and people buy into it. And so we ourselves, even at the bar, we have to try our very best to dispel those things, to walk persons through how the process works, and not only how it works, but because I always tell people the law can work for you and against you. You can think you have a great case, walk into that court, and by the time you leave in shambles. You have to come back the next day. You just never know what can happen. And so people kind of associate that, you're against me, or, and it's that trust and confidence in our systems. And so it's not just, it's in the judicial system, it's in our political system, that trust and building that trust and confidence, and also having that trust and confidence in our people. Because you believe it or not, some people, and I've experienced it, I've had discussions with people, they believe because it's white, it's right, because it's from England, it's right. And so you have to have your trust and confidence in our jurists. And the Caribbean has produced top-notch, internationally acclaimed jurists that sit on courts around the world, right? And even in our Eastern Caribbean Supreme Court, you look around at the court, and we've had persons who sit from all over the world. They come and bring their experience, their expertise, and their strategies. They've written books, they've written papers, if you follow them. And so why not have our trust and confidence in that? And I think as a people, we struggle with that. We struggle with our own self-identity. And I think it's something, Independence 41, together proud and strong, they said. Together, proud and strong. We have to look at it and really do some self-awareness. And we have to look at it, as a people, as a Kittitian Nivishan people, we have to look at what do we want? How do we want to shape our society? What are our values? What are we looking to have? And those are the kinds of conversations I think we need to have to kind of explore, the court and where we want to go. And one person I admire is Mia Motley. I admire that lady because she's come in, And they used to call Barbados Little England, that's what they called it. The number one place they called it. And now she's just debunked all those things. She's gone to becoming a republic. She's taken down statues. She's building Bajan identity. And I'm not saying, because we have our own identity in St. Kitts, the islands are the same but different. And I think we have to take a little nod from her and look at how we can build our own identity. And it's no different that why Barbados is actually one of the countries that is actually a part of the Caribbean Court of Justice.
So what's that process like? Do we have any legal barriers preventing us from moving to the next step? Let's say today is what? Wednesday? Okay, so Monday, next week Monday, just to be correct.
I think
next week Monday, cabinet meets. Hear me out. Next week Monday, cabinet meets, and the Honorable AG moves this discussion and says, I am sternly of the opinion that it is time for our nation to transition to using the CCJ as a final appellate court. And then our Prime Minister accepts that, and they decide this is the move we're going to take. What does that look like legally? Does our Constitution provide for that? How does it look like? What does it look like logistically in terms of the withdrawal from the Privy Council and the move to the CCJ? Let's discuss that for a bit.
Before we go into that question, with your permission, of course, I think just to support a little bit of what Nisharma was saying on the whole idea of the con, right, is that I think if we lay all the cards on the table in the argument, the cost, the accessibility, talking about the colonial legacy, how a move to the CCJ will help us to appreciate and deepen the regional integration movement. We will come out on this side of let's move, let's go to the CCJ. But there is that one argument, and I think it's more imagined than real, about the trust in the judiciary. And we have examples because my research tells me that Guyana has not been going to the Privy Council since around, I think, 1970. We don't hear any, Guyana hasn't broken down. Guyana hasn't stopped functioning. Guyana is a prosperous country.
It's the foremost
they've had,
their own right
economic issues, but look at where they are now. But since 1970, so I don't think the earth will cave in. I don't think that St. Kitts will go up in smoke if we move.
So you don't think that there will be any negative impact to our judicial system?
None whatsoever. I don't think so. I think that the judges that sit at the CCJ are as capable as the judges. And we don't just use judges from the Caribbean region.
Yeah, that's another point.
When a vacancy notice goes out for a judge, this judge can come from anywhere. The difference is that in one instance, we have to go to the judge in England. And at the CCJ, there are judges who are hired from around the world, but they have to come sit with us. Yeah. They can appreciate how hot sun is and that there is going to be no snow. And they can get an appreciation of where Mack is and where St. Paul's is, because our criminal judge is a British citizen.
He is.
And I've just begun, taking up High Court criminal matters, and having gone there, he knows St. Kitts. He knows where the street is, and he knows, he knows the names, right? Because he has come to us. We are not going to him.
Because you can come, but you don't have to drink. Yeah. So
the one con of that we can't trust, judicial decisions coming from, a Caribbean court. I think it's imagined. It's not real. but it's
That's a
used.
whole big conversation about the separation of the judiciary completely, and people have strong opinions about there actually not being a separation. I would love to delve into that, but today we have to focus. And I know Talibah wanted to weigh in a bit, and then we would shift it a bit more as we go back to the CCJ side, in terms of the process. But Talibah, just weigh in, and then we could go to the process.
Because a lot of these ideas, they do come from the colonialism era. They do come from that period where our ancestors, most of us, I think 90% of us, descended from people brought from Africa and enslaved here and stripped of their own identity and inculcated with the notion that English is best, white is right. And not only that, but that we should distrust one another, that we should consider each other to be probably lacking in integrity, morally corrupt, or at least having a higher propensity to be more corrupt than an English person. Some of these discussions are still rooted in those ideas, which are very harmful and they're very untrue. Okay, and the reason why they came about is to keep us subjugated. I think that once we get to understand and appreciate that, we will stop arguing, I think, from the default of having to prove why we have to govern ourselves, why we can govern ourselves. We're arguing from that place as though we're not independent, and we have to prove why we can cut the umbilical cord once and for all. And just in case we still need convincing about it, in any event, the CCJ has the most robust safeguards in place against external influence, against political interference in the world. And scholars have said that from this region and from elsewhere, and from the same England as well. Scholars have published on that. There's a Professor Kate Mallison who did 3 years of research into courts around the world and found that the CCJ is a model for the world in terms of judicial selection, in terms of recruitment of candidates, because there's no politician involved in the handpicking of judges on the Caribbean Court of Justice. There's no politician that can say, I want John Brown to be the president or to be a judge. The only time that politicians do have some input is with respect to the president of the court. After the independent commission goes through a rigorous process and recruits someone and makes a recommendation, then the CARICOM heads of government have to approve the president. But even then, they can't say, actually, I don't like Nisharma, bring Mary. No, you have to deal with the recommendation before you. So there's no handpicking. There are very robust safeguards in place and transparent safeguards.
Forgive me, I've been out of private practice for some time, and the old brain is a bit foggy. I'm in the civil service. That's enough said on that. But what I'm hearing here is that the CCJ is leaps and bounds ahead. We've heard all of the pros. We've heard some of the cons, whether we feel they're real or not. Why then? I'm just going to ask, because I have lots of questions here to ask, but the one in my head is, I hope they let me come back after this question. The one in my head is, with all of these benefits, with all of this structure, with the fact that we know going in, the pros, what we have to gain, why haven't we gone there yet? Other countries have done it, as you've indicated, Barbados. What is holding us back? And we can be candid. Can we be? No, we can't be candid, sorry. But we can be candid enough. What's really the problem?
I think I can be candid enough. What I think we were trying to get around to this point, and what it really takes is political will, right? Political will and political maturity. I think Crios and I were discussing this prior to. Political will and coupled with political maturity. And will in the sense that you have to have our leaders looking at these topics, looking at where our country is heading. Like I said, back to what vision do we have for a nation? And looking to see, is that a mandate I'm going to take up for the people? It has to be a mandate. And it also has to now go over from political will to political maturity, where both sides of the aisle can sit down, come together and say, this is in the best interest of the country. If it is in the best interest of the country, all hands on deck, everyone on board, we present it to the public in a united way, and we start real serious discussions, town halls, awareness
campaigns.
Because that's very, very important. You'll be surprised, the man on the street, not even knowing what, they say, CJ, who's the president? They don't even know that, right? And so you have to have that serious awareness and, you know, get into the people to discuss these types of topics and what the benefits are, and create that buy-in, I like to call it.
Buy-in is important.
Right? Citizens have to, as leaders, you have to create the buy-in so that the citizens can come together and buy into it and understand the concept, understand and have real discussions, not about, oh, my party said this or that. No, you have to have real,
100%.
solid discussions about this with the bar, with the, you know, have persons come out and really present this argument to the public in a way that is non-political, in a way that is for the benefit of the country.
And in a way that they can understand.
And in a way that they can understand. So that it's more, you know, everyone can take it on and we can all have a united front together, proud and strong. I like to go back to this. Yes, to this. Proud and strong, Independence 41, so we can have that launch to go into the next era of our independence, the next era. What is the vision? And I like to go back to history. And I have to give a nod to my mother. She's a historian by heart, and I always have to go back to history. Because we had the leaders of our bratchers and all these persons who had visions. Self-determination was their cause at the time. That was their cause at the time.
They did have a bigger cause.
Self-determination for our nation.
For our nation, that's true.
Right? Then you had the leaders from Kennedy Simmons, you know, Dr. Dennis Douglas, now, you know, looking at, okay, well, now that we're out of that, where are we going to next?
What's the fight?
What's the next, right? Now we're into a new modern age, 2024. And we now have to pick up as a nation, well, what is the next step for our country? What is that next level? What are we going to be looking at? And each phase of our country's history, you got to look at it. And you have to identify what will be that next thing.
So are we saying then, can we say, and I want to hear from everyone, just a quick yes or no, based on what Nisharma just outlined in terms of the next step, are we saying that this transition to the CCJ, do we think that that's significant enough to be included in the next step?
I think so, of course.
You think that has to be included? Of course.
I would say yes, and on that yes though, I think carry the conversation a little further, Leah, because in answering the question as to why not, why aren't we there, we were verifying just before we came on camera exactly what is required, and you asked the question moments ago on the process, right? And I think in understanding why not, why we aren't there, we have to understand the process that is required. But in understanding the process, it makes me even a bit more perplexed as to why we haven't gone on that journey in St. Kitts. Because the process we confirmed requires a supermajority in cabinet, in parliament. And for us, that's 7.3. But you don't count piece of people. So you need 8.
Oh, so you have to round up.
Yeah.
Even though it's under 0.5?
Because
it's more than the 7. Okay, there we go.
Yeah. So 8
seats.
So
elected.
Out of 11.
Elected. We're talking about not senators. Not 8 votes. 8
elected.
Okay.
Yes. Right. And so it's at least 8 if it's elected, and if it's more than that, if senators are included, then we have our 8 electeds. We have 3 senators on one side, that's 11, and 1 on the other side.
Yes.
That's
one on the other side. Yes, for leaders. Yes.
No, it's 11 elected.
11 elected.
And 4 senators.
Yes.
So that would be 15. And the supermajority in that case then would be...
It's only representatives, so
It's
it's
only-
only
So it's only
only
those
So it's out of the 11.
elected. So it's 8. That's confirmed, right? That's all we need. In 2000,
So that's
when
for the
one-
votes. That's for the votes, right?
Yes.
Yeah.
But what I want to get at is, in order for us to vote on this, so they've gone to cabinet, they've said this is what we're going to do, they come to parliament, they agree. Let's say they've done all of their awareness, etc. What does it cost? Is there a major cost?
There's zero cost to joining the CCJ in its appellate jurisdiction.
Okay, so
The
is there
money
a
has
cost to
already been
withdraw
paid.
from the Privy Council?
There's zero cost involved in doing that.
Is there a process to withdraw from the Privy Council?
So the Constitution requires not only the 2/3 vote in Parliament, and that the readings have to be 90 days apart. So the first reading of a bill to change the Constitution, you have to have at least 90 days elapsing before the second reading. And so, but you also require the agreement of the His Majesty.
Yeah.
Okay, now Her Majesty, the Queen Elizabeth II, who was there before, she had never had an issue with providing that agreement to Barbados, to Belize, to Dominica, to St. Lucia, which are the 4 other countries in addition to Guyana, which have already made that leap. So, and we've been told that there would be no issue if we require that agreement as well. Yeah? So that's the other thing. We need the 2/3 in Parliament, but then you need the agreement.
And we need the agreement. So basically, in terms of timeline, we need at least 4 to 5 months around
Something
there.
like that.
Well, just in the event.
stretch it out, yeah.
Just
Assuming, yeah.
Right.
Yes. Yes.
And so let's say 5 months. Let's call it 6. We're rounding up today. 6 months, 8 persons approving, and the king, the monarch, saying yes.
But Leah, what the
I
way
know I'm oversimplifying it.
No, I don't think so. Because I want to advance the conversation a little further. It's something we spoke about off here as well. Is that we have never had, since 2005, we have never had any serious conversations about joining the CCJ in St. Kitts and Nevis. There has never been. None of the political parties has ever placed it on their platforms going into an election.
Have we?
There has never been, I think, any campaign on the ground. I'm sure there have been conversations here and there from the Bar Association and so on.
Yes.
But I don't think there has been any serious, well,
Never
none
been
that
at the
I have
forefront of any
noticed.
discussion, any national discussion.
And yeah,
That's
that is what I don't understand, because the countries that have accepted the transition to the CCJ are those that don't require a referendum, right? Because that is where the difficulty comes in.
Organizing
It's
that
not required
referendum.
here in St. Kitts and Nevis, but I don't understand. It's something that, being invited to this conversation, I'm going to have to ask, the politicians at least who I have access to.
Let me give you some questions to ask them.
As to why, because...
Let me give you some
know?
questions, for food for thought, but for us as well, but as you carry it on to them as well. Do we think it's a situation where, and this has permeated our society from inception, where if it's not broken, don't fix it, don't change for change sake? Do we think that that's one of the issues? This is how it's always been. We love that. Oh, this is how we've always done it.
Yeah.
Right? Do we think it's a case of that? That's one. And two, do we think that there will be any significant fallout for the administration that moves forward with that move? Do we think that perhaps in the backs of their minds they're thinking this is something that could cost us an election? Do we think it's that serious?
I don't think so. I mean, the court has been established since 2005. This is my issue. Since 2005, we're here in 2024. I think the court has proven itself. It's tested. It's, you know, you have solid judgments coming from
Have we sent cases there in the original jurisdiction?
We actually, I think, we didn't send, but we were involved in one about sugar.
The Belize
actually,
one?
Belize, yeah.
But it didn't go through.
No, it didn't, because they settled everything prior. So
God.
that's what I'm saying. So I
We
mean,
would
we
have
are
lost.
actually
Bad.
we are actually a part of it, and with the trade and different things like that. And so we actually are a part of the court in essence. And so, like I said, the court has been tested. It's there. It's, you know, I think it's on a solid ground right now with the president, Adrian Saunders, presently. And I think, you know, for any politician who's picking it up, I mean, it's there. You have the record. You have the track record that you can refer to the members of the public and the citizens. That's been years, and it's been there functioning, and I think as a legacy of the Caribbean. And persons look to the court, as Talibah mentioned, as a model court. You know, it's an indigenous court. The judgments, I read the judgments, sometimes pop on just to read what's happening. And I mean, they deliver solid judgments. They even give advice to governments, you know, in their judgments, telling you, you know, what the things you can employ, what you can do, what you can change. And I think those are things that maybe our politicians need to look at and just pick up on. So I don't think it would be a negative in taking it as a mandate. But I guess it's for the powers that be who are listening here today. To take that up and consider it maybe for the next election cycle.
It has featured, I think, in some manifestos, but nobody's ever going on the platform and saying vote for me because of this. Because courts are not an issue, and the legal system is not an issue that voters necessarily think about until they're faced with a problem. So I think that's one of the issues too.
It's not a vote getter.
It's not a vote getter.
Correct.
It's not one of the sexy ones.
Yes.
You know, people are voting for maybe the hospital or roads.
It's like I was saying earlier, it's not sensational enough. You know, people love the sensationalism.
So
and it's a bit on the boring side. But it's important. It's critical.
That is why awareness.
That is why I wonder if it will create much controversy if we take the leap, and I don't think so. One has to look at the realities, however, in Parliament. The government has 6 seats. In order to get this through, it will have to speak to the other side. Will the other side come on board? We have been. There's always a battle in Parliament. There's always, and that is what really affects those countries that have to go the way of referendum, right? Because the opposition just doesn't encourage its people. As a matter of fact, opposition parties in the countries that have gone the referendum, and we've had quite a few that have failed. We had 2 in Grenada. There was one in St. Lucia. There was one in Antigua.
St. Vincent.
St. Vincent, yes, St. Vincent. Sorry. In Jamaica, the bill that was proposed to transition was passed in the House, but blocked in the Senate. So by one vote. So, and it has never really come back up. In Trinidad as well, there have been failed attempts there under the Bessesa administration.
My biggest challenge is because it is the home of the CCJ, and I just feel, as Nisharma raised earlier, we all contribute to this court, to the running, the operations, etc. And you select the home base in a country that does not recognize it as its final appellate court. That's where the affront is, if we want to use the word affront.
Because there is, you see, if you understand the political divide, it's easy to understand why they fail. Because elections are close calls in most countries. Even when a party might get all the seats, the popular vote might still be close.
It's still 48,
right?
52,
so
49, 51.
So it's a competition.
That's a point.
One party is in power. They begin the move to transition to CCJ. The opposition party, all they have to do is to is to convince a few of their supporters that they're trying to get to you, they're trying to take total power. Because remember, you need a supermajority, it's not just 51%. And so it's easy. And remember, politically in most countries, we are divided 40-something, 50-something.
It's not right?
So it's hard to get, as a matter of fact, I think there was some that got over the 50%.
In Trinidad, yeah.
But you need 66, 67%, so that's the difficulty. However, that brings me back to St. Kitts and Nevis. There is no need for a referendum. So
We've never tried.
Is there an opportunity here for 2 members on the opposition benches to vote in favor of this along with the government? I'm taking it for granted that everybody on the government benches would want to go to the CCJ, but we need 8 votes. It's something you can call your own. It's like UE that has major successes.
Yeah.
You know, it's like the Eastern Caribbean Supreme Court.
Yeah.
It's like the Eastern Caribbean Central Bank.
No, one
it's
thing
like the
CARICOM,
OECS Economic Union.
One thing CARICOM has gotten right is its functional corporation, which is why I'm really surprised at the delay in CARICOM territories coming on board with the CCJ, because typically when you look at our regional institutions, that's CARICOM at its best. I'm really at a loss for words, but we're also at a loss for time. So as we head into the wrap up, what I'll do is I know you all have some more that you wanted to share. So this is how we'll do our wrap up. You are all in Parliament representing your constituencies as elected representatives, and the discussion tabled is CCJ versus Privy Council. Should we transition? And by we, I mean St. Kitts and Nevis, as we recently celebrated our 41st independence, our 41st anniversary of independence. On the table in Parliament, to you 3 representatives, should we transition to the CCJ? And your arguments for? Well, I'm presuming, based on what you've said, that we're all for. So these are your closing remarks as we wrap up the debate, and you're leaving me, Speaker of the House, the only time I'll ever be able to call myself that, the Speaker of the House, with your rationale for support of St. Kitts and Nevis transitioning to the CCJ as its final appellate court. Talibah, I'll start with you, yes, because we're going to come back this way.
All right, Madam Speaker, well, thank you very much for the opportunity to say these final remarks. The CCJ, it's something that we can call our own. It's something that will allow us to close that circle of independence and be able to say that we fully govern ourselves. There is no greater position of authority or leadership or importance that you can give to someone than to have the final say on your decision making. On us right here in this assembly, Madam Speaker, we're passing laws here which go up to a court in a foreign land which has the final word on the interpretation of our laws. In my opinion, that is antithetical to true independence. It is antithetical to a situation where we say that we are truly governing ourselves if our own laws are not subject or outside of our own control. The CCJ, on the other hand, Madam Speaker, it is a court which has, as I said before, the most robust safeguards in the world. The judges are subject to a code of conduct. There are disciplinary procedures for judges. It's all transparent. They produce annual reports of their work. They see that they have a duty to account for their performance. And those reports are on their website. You can look and see what the work is that they have been doing. The CCJ at this present time, it operates for a total population of about 1.7 million people. Guyana, Belize, St. Lucia, Barbados, Dominica. That's right, right? Okay. For the year, they've done 17 judgments. You can look on their website. But from the beginning of their time, they've done hundreds of judgments for that small population of people. It is not uncommon for new courts to take some time for people to join them or for countries to join them. There's the example of the European Court of Human Rights. In the first 10 years of its existence, it had 10 cases in 10 years.
10 years.
Right now, it has about 130,000 cases pending before it. It takes time. But in the CCJ's first 10 years, or even first 20, they're just about almost 20 now, they've done hundreds. So they're actually ahead of regional courts like them and international courts like them in terms of getting support. It's just a matter of time. I think in a few years, we would actually be laughing at the fact that we're still having a discussion about whether we're capable of taking this leap on our own. So the Privy Council's total population that they service, on the other hand, is about 7.5 million people. They still only do probably about 1% of the cases that come out of a court of appeal generally. So Jamaica, Eastern Caribbean, Supreme Court, Trinidad, etc. There are very, very few people who have that last bite at the cherry of justice. We operate at this time, Madam Speaker, so finished. We operate at this time.
You have 1 minute.
It's almost like we have a two-tier system in practice. High Court or Magistrates Court and Court of Appeal. The vast majority of people, unless you're very well backed, and I mean financially, you're not going to go much further with your case. So the point is that if you do find yourself with a dispute with your neighbor or whoever it is, don't you want to have that access to justice of that last tier, which in practice, most people do not get the bite at. Our neighbors in Guyana and in Barbados, Barbados when it joined the CCJ, in the first few years, cases increased by 300% and sometimes more. Same with Belize, the numbers increased exponentially of people going. Because the logistics are easier, the cost is much less, it's much more accessible, and like Crios said, the earth didn't cave in any of these countries, which has abolished the Privy Council. The economies have not failed, investor confidence didn't go down. There's been no disadvantage. In fact, not even any of the governments lost. Actually, if you look at it, after they joined the CCJ, as a matter of fact, in Barbados, in response to a ruling against his government, I think it was Prime Minister Frondel Stewart at the time, who was the Prime Minister just before Mia Motley, he campaigned and said, if I win the next election, I'm going to abolish the CCJ because they're making cases against my government. Yeah. And that's for the people who think that the CCJ will not issue judgments against the government. They do actually at the same rate as the Privy Council does. So let's just get that clear as well. But Frondel Stewart was pretty upset with the CCJ and campaigned and said publicly, he's going to abolish it, elect me again. And he lost every single seat. So here we are, Madam Speaker. I'm going to thank you again and to the organizers as well for having me today. And over to my member from number 6.
Thank you, member from number 1. Member for number 6, you have the floor.
You might get some people upset. Madam Speaker, I am happy for this opportunity. However, I'm going to be very brief because I think the member for number 1, as we're referring to her, has really made the substantial arguments that need to be made. I think she was very thorough, and I think she touched on all of the issues. But above all, I want to give my support to her and to echo my own support for moving towards the CCJ. At the end of the day, all of us want our own. We want our own homes, we want our own cars, we want our own education, degrees. As much as some people will say that they are okay with being the side dish, They want their own relationships.
Amen.
We want our own children. This is an opportunity for us to have our own. There is nothing greater than that pride of having your own thing, something that belongs to you as a people. And so I think there is really, in St. Kitts and Nevis, no serious impediment, except if I am to lay any blame, I would lay it at the feet of our politicians, of our members of parliament. And now is the time for significant political maturity and for us to do what is in the best interest of our country and for the legacy of our foreparents, and to build some stability on which generations to come can found their own lives on. With that, I support the transition to the CCJ and hope that we can get the 8 votes required to make that move.
Thank you, member for number 6. Honorable member, which number are you for?
6.
Number 6, let's put you at 2. Honorable member for number 2, you have the final words.
All right. I wish to support my members here with me today. And I just want to emphasize, I think what it comes down to in I guess in society is people's pockets. So that's the one I'm going to emphasize, the money. When you have to look at the costs associated with what is spent to access the court in England, the Privy Council, it is exponentially greater than that of the CCJ. And I think that's the bottom line when it comes to persons and accessing justice. You have to look to see, how can I access, how do I want to access? And that money factor is one of the biggest factors that I think impedes persons from carrying on their cases. And so with looking at the courts, how they've developed over time, looking at the CCJ, their accessibility, their technological advancement, how things have changed, how our access has changed, I think that would be the most beneficial thing. Of course, buttressing the arguments by my friends. And the last one I would like to make is really that self-actualization. I want to echo those sentiments because I think it is very, very important. And I think it's, a testament for to a legacy for us, even for our children, to see that you can have your own, that you believe in yourself, you believe in your court, you believe, and I'm a staunch regionalist, you believe in your region, what you can do. Not because we're small, we come together, and I mean, we've produced the best and the brightest, whether in sports, whether in politics, whether in jurists, whether in this limited geographical area. And so I think we have to believe in ourselves, and that would be a testament and a value that we should be, carrying out through our society. And so I implore you, members of the public, to visit the website of the CCJ. Do your own research. I implore teenagers, I implore young people to look at these issues, head on as we face, what the future of St. Kitts and Nevis looks like. And I want to see a better St. Kitts and Nevis, together proud and strong, and together proud and strong with the CCJ. So I will leave it there and turn it over. And I want to just thank everyone. Thanks my colleagues for being here and having such a great discussion, and Leah for guiding us along. And thank you so much.
Well, it was certainly a pleasure. Y'all reminded me of what it is to be an attorney. And apparently, the law sits with you no matter what. She's a jealous mistress, but she doesn't leave you alone, Crios, no matter how many side dishes you have. But really, it's been a fruitful discussion. So allow me to thank you all for taking of your time, sharing your insightfulness with us. Also to our viewing audience, thank you for tuning in and for watching as we discussed whether the CCJ or the Privy Council. Based on what we've expressed here today, what we've learned is that this discussion isn't just about legal matter or the court. It stretches to our sovereignty, it stretches to our identity as a people, it stretches to the future of justice, not just for St. Kitts and Nevis, but as a region, as a CARICOM unit. Of course, Be sure to join us next week as we host another special edition of In Focus, where we bring you conversations, reflections, and the way forward. Our next topic, ironically, will be digital transformation, connecting our digital dots. And we heard a bit about that and how that has improved the legal system within the CCJ. So looking forward to that discussion next week. Until then, stay reflective, stay engaged, and keep the conversation going.
The St. Kitts and Nevis Independence 41 Committee presents Conversations, Reflections, and the Way Forward. This interactive discussion series provides an in-depth view of the trials and achievements of the past, as well as the accomplishments, threats, and tremendous opportunities of today and in coming years that will transform the Twin Island Federation into a model sustainable island state, serving as a beacon for all. On this edition, CCJ versus Privy Council, the battle for justice.
Would you stand up and see your country dying?
The St. Kitts and Nevis Independence 41 Committee presents Conversations, Reflections, and the Way Forward. This interactive discussion series provides an in-depth view of the trials and achievements of the past, as well as the accomplishments, threats, and tremendous opportunities of today and in coming years that will transform the Twin Island Federation into a model sustainable island state, serving as a beacon for all. On this edition, CCJ versus Privy Council, the battle for justice.
Would you stand up and see your country?